you for inviting me here. I think I'm the only person from England who's attended it, which probably says a lot about England's relationship with Europe at the moment. I should also just correct that, just in case I get in trouble when I get home, I'm not a barrister, I'm a solicitor, which is the other arm of the legal profession in England. I'd also like to say how indebted I am to Rosaria, who this morning effectively did what was my job by telling everyone how awfully the UK is complying with its obligations to implement judgments of the European Court. One thing that she was far too polite to mention to you is that when the Prime Minister was asked what he was going to do about prisoners having the right to vote, he said the thoughts of giving it to them made him physically sick, which I think shows quite how debased the argument has become in England when it comes into the political sphere. The other thing that I'd also just like to thank Rosaria for, which I don't think has been dealt with in anyone else's talks today, is a mention of deaths in custody and quite how important that issue is, both in the UK but also across Europe. Because deaths in custody occur when everything in the system has gone wrong, and they serve as a warning of the system not functioning at all. And in the UK, the deaths in custody have occurred not just against the backdrop of overpopulation, but also against the backdrop of a cut in prison staff of 1/3, and an impoverishment of regimes where prisoners now start their weekend on a Friday morning, sometimes Thursday evenings, where they're locked up with no supervision for the next 48 or 72 hours. And that's the context in which it arises in our country. I'd also, before I start properly, just like to apologise to Hughes, because I think there was some confusion in my understanding of the technical terms of execution and enforcement about what he wanted me to speak about today. I am one of the few people here today who's not an academic or attached to an NGO, and so my experiences are very much driven by working with prisoners and day-to-day case experience. And so what I'd like to talk to you a bit about today is where I think we've got to with the European Court judgments in relation to the enforcement of sentences once they've been imposed, the parole schemes, and the conflicts that's causing, particularly in England, but across Europe, I think, and the implications that has for the individuals who are actually affected by those sentences. So, if the technology works, thanks to Rosaria, the starting point of European Court case law in relation to their enforcement of domestic sentences was that any domestic law sentence that complied with the procedural and substantive safeguards of Articles 5 and 6 at the time of its imposition did not raise any new questions under the Convention. Now, as you'll know, that was first called into question in the Van Druggenbroek case, which raised the first questions about the interplay of Articles 5.1 and 5.4 in respect of the enforcement of sentences. And the underlying basis for the finding of the violation of Article 5.4 in that case was the fact that the grounds upon which the sentence was originally imposed might be subject to change. And that finding then came to be examined in a whole succession of cases from England and the UK. Starting with the Weeks case, and then that line of authority effectively reaching its conclusion with the Stafford case. And those cases were coming from England because of the peculiar affection that England has for imposing life sentences. As Rosario told you earlier, that there are more lifers in England than the rest of Europe put together. But they reached the conclusion that any fresh decisions about detention have to be compliant with Article 5.4. And the classic statement that you'll find of that is taken from the Weeks judgment, which I've just put up there for you to save you having to read it. Now, the time at which the safeguards of Article 5 are re-engaged for prisoners serving indeterminate sentences is at the end of the punitive period, what we also call the minimum term or the tariff, and on the occasion of any re-detention following that person's actual physical release from custody. And it was for domestic law to make a decision about when that punitive point had been reached, as long as that decision was made in accordance with Article 6. Now, although that decision from Weeks is now approaching 3 decades old, it essentially represents the key breakthrough that was made by the courts in respect of their superintendence of the execution of domestic sentences. But in my view, it raises 3 further questions which are now becoming much more prominent and which require a much more structured and considered development by the courts. And the current questions that I would suggest need to now be answered are in what circumstances does the state have to guarantee the right to a review of sentence, and that's the whole life sentence issue. What further guarantees must exist so that a sentence is reducible both as a matter of practice as well as law, and whether these principles have any applicability to prisoners serving determinate prison sentences. I should add to that as far as the UK is concerned, there should probably be a 4th question, which is the imposition of life sentences on children compatible with the Convention? I suspect it's something that's a peculiar problem for the UK, that the rest of Europe probably doesn't hand out life sentences on children hardly at all, and if so, not in the hundreds a year that are imposed on UK citizens. But I think it's a very important question that probably has to be looked at on a domestic level before it reaches an international decision. So looking at the whole life sentence issue to start with, the first question that I'd like to ask is, why is it of any importance? As Rosario told you earlier, there are only 58 or 59 people serving whole life sentences in England and Wales. When we did the research to find out what was happening across Europe, my understanding is there are only 10 member states of the Council of Europe who impose life sentences that can be whole life or have no proper system of review. And so you might think that it's a very narrow problem. But the whole life sentence issue does interplay very intimately with the rest of prison sentences, with what people can expect in prison, how can they expect to be treated, and the fundamental question of what the purpose of imprisonment was. And I think that's quite well illustrated by this quote from the Dixon versus UK case. And that was actually a case that concerned the right to artificial insemination for somebody serving a long prison sentence. It wasn't connected with his life sentence. But that was a case that was extremely important in establishing the principle that whole life sentences are in breach of Article 3 of the Convention. Because it was that case which established the progression principle. So where that took us to with Winter was the view that a lifelong punitive sentence breaches Article 3 if there's no dedicated review mechanism available to the prisoner from the outset, which must satisfy the following criteria, which will probably be very familiar to you. The formal recognition in Winter that a lifelong punitive sentence with no prospect of release breaches convention rights because it fails to incorporate these concepts of resocialisation and rehabilitation is extremely welcome. But I think that one criticism that can legitimately be made of this judgment is that what it does is it loads the problem into Article 3 and diverts it away from Article 5. And by finding the solution in Article 3 and not Article 5, it raises more questions than it answers. And so what we've seen since the Winter judgment has been a problem not just in the UK, which I'll address in a second, but also across Europe as a whole. And so since Winter, we've had Öcalan versus Turkey, Magyar versus Hungary, Trabelsi versus Belgium, the Tolomov and Bulgaria case. And so we have these problems arising in a range of jurisdictions. And because it's been viewed through the prism of Article 3 and not Article 5, it leaves too much for the national courts and the national legal system to resolve, without having a solution that's at a supranational level, as happened in the cases of Weeks and Stafford that preceded us, where the supranational solution under Article 5 imposed a requirement on the national courts. Now, the high watermark of the current situation is the Murray versus Netherlands decision. And what's so critical about Murray is it concentrates on the practical reality of whether a life sentence is reducible in practice or not. So I'll give you the key quote from Murray. But I think that in analysing the question of whether this should be an Article 3 or an Article 5 issue, it's actually really helpful to go back to the Leger case and the dissenting judgment that was given by Judge Costa in that case. Because what he did was he provided an extremely powerful analysis of the importance of the superintendence of the court over domestic parole decisions. And I've given you a key quote from this judgment. I can't remember if I put them all on. Okay, so Judge Costa asked a particular question that has to apply when you're looking at how domestic parole systems work. And I think that then one of the earlier speakers made reference to his wild beast human waste question here. But what he said is that it may be that domestic law creates parole and it is a right that exists only in domestic law, whether that's for people serving long-term and life sentences or whether it's for people serving determinate sentences. But once that right has been created, and it's a right that the European Court has to exercise jurisprudence over, otherwise it's a right that risks becoming wholly arbitrary. And to illustrate how that's occurring in England, what happened with the whole life decision in England, immediately post the Vinter judgment, well, in fact, immediately before the European Court Grand Chamber sat in the Vinter case, the Court of Appeal in England specially constituted itself. And I have been told that it specially constituted itself at the request of one of the government advocates in the Vinter case, which raises concerns about the separation of powers, and said effectively that English law was completely compliant with Article 3 because, of course, the English Secretary of State would always exercise his compassionate release powers compatible with Article 3. That judgment was then relied upon by the UK government in Vinter and was roundly rejected by the court. But as soon as the Grand Chamber gave their decision, another specially constituted Court of Appeal convened itself in McLaughlin. And when I say specially constituted, what they did was have 5 judges instead of 3 judges, which gives it extra special authority in English law, making it very difficult to go beyond that. And this specially constituted court was even more of a concern because one of the cases it was hearing was an appeal by the state against a sentence that they considered was too lenient because it was 40 years and not whole life. And the prisoner who had received that sentence had decided not to be represented because he felt that he fully deserved his punishment. So we had a really important question of law decided on an appeal by the government where the prisoner had no legal representation, although there was one of the person in that case who was represented, so it wasn't quite as bad as it might seem, but it was about as bad as it gets for domestic law. And the McLaughlin decision just said the European Court don't understand, but now they've told us we will of course always exercise our domestic law compatibly with Article 3, and that's the end of it. Since that point, Mr. Vinter has been trying to relitigate the matter domestically to argue the points in domestic law. And unfortunately, because of that blocking 5-judge Court of Appeal decision, it's very difficult for us to move forward, although we are appealing back to the Court of Appeal about that at the moment. But the real problem that's been standing in our way was the subsequent decision in Hutchinson, which for some reason simply endorsed, said we must treat this as a matter of domestic law, The Court of Appeal in McLaughlin have told us what domestic law is, therefore we must respect it. Now, as you know, that's been appealed to the Grand Chamber and we're waiting for a decision. And one of the things that I was very proud to be able to contribute to the PLN was to help with the intervention that was submitted to that, which will hopefully cure some of the blockage. But I think that this sorry sequence of events is quite a good illustration of the difficulties that have been created for us by the European Court shunting this into an Article 3 issue, when by rights the complaint should be Article 5, and it was forced artificially into Article 3 because of previous case law from the European Court. So the second point that I'd like to move on to is what this means for the right to rehabilitation in practice. And I've put up this quote from the Koroshenko case to again illustrate about the interplay and the importance of the concept of resocialisation and progression as being at the core of prison sentences. And so whether they apply to whole life or whether they apply back here, as they did again, like in Dixon, to the family life issues, the right to conjugal visits, that the two matters are intimately intertwined and affect the day-to-day lives of people's imprisonment. But once again, despite these principles, we're then left with a problem that has arisen from the UK about what does this mean in practice? What does the right to rehabilitation mean in the case law of the European Court? And I'd just like to tell you a little bit about the background to these cases, James and Kayam versus UK, because I think it's quite important not to lose sight of the humanity that's involved with these types of sentences. What the United Kingdom did in the 2003 Criminal Justice Act was it invented a new form of life sentence. And they gave it the name of imprisonment for public protection, which was meant to soften the blow and make it less like a life sentence. And when it was first implemented, it was a mandatory sentence that had to be imposed on people who had been convicted of certain specified serious offences. And the list of specified serious offences, sorry, the second conviction for serious specified offences, and the list of these serious specified offences started with the types of things that you might expect, like murder, serious armed robberies, but they went all the way down to really minor offences in English law, like a fray, and they also included robbery, which can be an exceptionally minor offence in English law that can be a major one. And the immediate impact of this was that the British number of lifers increased from 5,000 to 12,000 in an incredibly short period of time. And even more disturbingly, people were receiving punitive terms as low as 9 months on a life sentence. And as I say, to give you a human example, one of the first cases that I was asked to deal with was for a young woman who had 2 convictions for robbery, one when she was a juvenile, which was a minor street robbery, and the second which had occurred when she had an argument at a telephone box. It gives you some idea of how old this is, because it was before everyone had mobile phones. But she was waiting at the telephone box and she was upset that the person in front of her had taken too long. And so she had an argument with her when she came out, and the other woman was rude to her. And so she grabbed her by the hand and twisted her arm, and the woman dropped her purse on the floor. And my client picked up the purse and said, "I'm taking £10 as punishment for you taking too long," and walked off. Now the injury that was suffered by the victim was a slight reddening to the wrist, but because it had been physical force and the theft of money, it was classified as a robbery, and this woman received a life sentence. The tariff that this woman received was 8 months, and the length of time that the parole process takes to complete in England, if everything's running smoothly, is 6 months. So somehow she had to show that she'd been rehabilitated and complete a 6-month parole system in 8 months. And it was this type of case that led to this explosion of the prison system, and it led to a complete inability of the English prison system to cope with these numbers of people. And so the first thing that happened was there were no courses available for people to demonstrate that their risks had reduced, that they had rehabilitated. And the second problem was that the parole boards, who have the power to decide these people's release, completely broke down under the strain and couldn't cope with the numbers it was dealing. And so you had people serving sentences, in that case of 9 months, 2 years, 3 years, serving 5, 6, 7 years before they even came close to being able to take the most basic of courses. What happened in the UK was that this sentence was gradually moderated to try and limit the numbers, and eventually it was abolished. But the system is still full of people serving these sentences who can't progress towards their release. It's something of a national scandal. And the reason why I think this demonstrates the problem that we have for understanding the right to rehabilitation in practice under the judgments of the European Court is illustrated in these 2 cases. In James, when the system was at its worst, the European Court did find a violation, that there had been a violation of Article 5(1)(a), in the sense that these people's sentences had become arbitrary because they'd served so long over the punitive period before they'd been able to access rehabilitative courses. This was then litigated quite extensively in England to try and understand the implications of what James meant under the English system. And the English Supreme Court developed a theory of what they call ancillary Article 5 duties. And what they meant by ancillary Article 5 duties was that if the state is failing in its duty to implement the progression principle and re-socialise people by providing these courses, there is a breach of Article 5, but it's not a breach that would render the detention unlawful. It's a breach that gives you access to public law remedies to compel something to be done and to provide you with compensation. Now this judgment was then considered by the European Court quite recently in the case of Catholique, and the European Court had difficulty with this and said that in those prisoners' cases there had been no breach of Article 5(1). They said that it was fine for the English courts to develop this idea of ancillary 5(1) duties, but it was not something that the European Court was yet prepared to develop. And I think it is illustrative of the problem that we have if we don't apply Article 5 to the central issue of life sentences, and we deal with it under the Article 3 head. And the last point that I'd just like to touch on, keep it short, I know I'm meant to finish at 5, is the problem that we've got with determinate sentences. And there are 2 long-standing decisions of the European Court that set out the position in relation to determinate prison sentences. And I've set a quote out there for you, so I won't read that out again. But essentially, even if domestic law provides an enforceable right to release or parole, the European Court does not recognise that a determinate prison sentence raises any fresh issues of lawfulness under Article 5. Now, in England, this created an unusual position because we have a very formalised system of parole which gives a legal obligation to release people at a certain point of their sentence, albeit under supervision, and they can then be returned to prison if they're deemed to have broken the principles that underpin their supervision. And there was a series of cases where prison governors had been miscalculating those release dates, and the English courts found that that was a breach of Article 5(1)(a), because English law gave you a right to release, and that those people were entitled to compensation. But they were faced with the Brown and UK decision, which, if those people were then returned to prison, Brown and UK said that there was no fresh Article 5 issue arising. And so, just over a decade ago, the English Supreme Court held that the English law had actually gone further than the European Court, and that Article 5.4 was re-engaged when people serving determinate sentences were called back to prison. And unfortunately, because that progression has never been made by the European Court itself, English law has now been evolved fast. And in a judgment at the end of last year, in relation to something we call tagging, home detention curfew, the Supreme Court said, well, it was obvious that English law has got it wrong because Brown is still good law, Brown is what Europe says, and England should not be racing beyond Europe and giving people greater rights under the Convention than those that are recognised by the European Court. And so we have a problem that the case law of the European Court has been effectively stymied and it's been stopped at a very early stage. And then that has an impact back into domestic rights, which are being eroded as a result of the stasis that's occurred at the European Court itself. And I'll just end on what the future, I say, should be for determinate sentences. And we have to ask ourselves the three questions. I won't read them out to you because they're there. I'll just end by giving you a concrete example, again from real life. Unfortunately, much to my regret, I can't stay for the proceedings tomorrow because one of my client's cases has been called on for a hearing that I have to attend. And the facts of his case are that he received an 18-year determinate prison sentence for attempted murder. He was released automatically after serving 9 years under domestic law and spent many years living life in the community without any problems. He was then shot in the leg, and we're not clear whether that was a planned shooting or he just happened to be walking down the wrong street at the wrong time. And the police are saying they do not want him to be re-released because they have 200 security intelligence reports that they're not going to release about him. Now, under the jurisprudence of the European Court of Human Rights, that does not engage any Article 5 issue, despite the fact that this man had been at liberty for 4 years, had not committed any further crimes, and has been recalled to prison for being the victim of a serious crime himself. And it's for that reason that I think that the development of this issue for determinate sentences is something which really needs to be explored in all domestic jurisdictions to try and drive this forward for the European Court itself. Thank you very much.
Thank you very much, Simon.